Yes, sir.
My name is Michael McLaughlin. I represent the petitioners in this matter. We are here on appeal of Judge Bosford's denial of the application of the supervisory powers under 211 Section 3 with regard to the request to have Judge Murtaugh in the Superior Court recuse himself and rescind his post-trial decisions based upon discovery by the petitioners after his post-trial decisions of what appear to be substantial appearances of impropriety. Judge Bosford's three-sentence decision seems to be based upon the fact that there was an appeal avenue available, which we do not believe there was because Judge Murtaugh had specifically said in open court that he would not enter a judgment to prevent an appeal from being taken.
Well, he said he wasn't going to enter a judgment, so
Yes.
you couldn't appeal it? In other words, you filed a motion asking for the entry of judgment, and he said no because I don't want you to appeal?
Yes, and it'll be in the transcripts of one of the hearings. He had decided that he was going to order a new trial. It's a very muddled sort of decision in which he says he's going to order a new trial for one of the parties. He's going to disregard the jury decision with regard to the award. He takes on a responsibility for giving bad instructions to the jury, which he did not. And he instructed and said, essentially, we're going to have a new trial, and he's going to award $15 of damages on the $1 million that was actually awarded by the jury. Now,
$15 of damages? I'm really confused now. What are you talking about?
In his decision, he awards, I believe, $15 and maybe $15 of damages.
This is on the 93A claim?
Yes.
Okay.
Yes. And so when that all occurred, the plaintiffs...
so there was no jury award on the 93A claim?
No, we had
because that's not a jury issue.
Well, it can be, and we asked the judge to allow the jury to hear it. The jury can also give an advisory opinion, or the judge can keep it. He elected to keep it.
Most judges do. I
Yes.
don't really recall a jury 93A, but
there are three options there, and so he decided to keep it. Now, Judge Bosford's decision said there were and are avenues to seek through normal channels that are available to the petitioners. And this case involves a very difficult property which the jury determined, as did the Department of Public Safety, that this building was in violation of building codes, 22 separate building codes. The jury determined that it was unsafe for human habitation, and that the jury, on all 17 questions provided to the jury found that the Culleys prevailed. After the trial, and after we heard Judge Murtaugh's and read his decisions, they seemed so inexplicable to us that we elected to make an investigation to determine whether there was any justification or whether there was any connection between Judge Murtaugh and the opposing counsel. It was in that investigation that we quickly found out that Judge Murtaugh was on the board of directors of the YMCA.
And did you file a motion that he should recuse himself?
Yes, we did. We filed a notice, Your Honor.
Well, I mean a motion. Did you file a motion? There's motion practice here, which is regulated.
No, we did not, and there's a reason why. We had looked at this extensively as to whether or not we should be putting before the jury a situation where we start identifying evidence of appearances of impropriety before a judge, and then have the other side ingratiate themselves to the judge saying you did nothing wrong, while we were saying, yes, you did something wrong. Now, we looked at Chapter 211, Section 5, dealing with issues when one raises problems of appearances of impropriety as it relates to the Judicial Conduct Code. And there is a provision in the Judicial Conduct Code that says there is always the chance of retaliation. So what by the judge, and therefore, if you file a complaint against a judge, you are to, the Judicial Conduct Committee is to keep that as private as possible and hide the name of the people who filed the complaint. Well, obviously, we could not do that. But the issue, after I discussed this with many, many people, was that this was not something that we should be involving ourselves in by way of having one side say to the judge, you didn't violate any ethical considerations, and there's no appearance of impropriety, while we are saying, yes, you did. So we filed an extensive notice, which we copied to the other side. The judge simply said, file it under 9A. We believed at that point that it was inappropriate to do that, notwithstanding the fact that there is a motion practice, because we were now on very difficult ground with regard to the types of things that we had uncovered about Justice Murtaugh, including the fact that the attorneys on the other side had represented the YMCA in litigation when he was on the board of directors, which is prohibited. He cannot be on a board of directors of any organization, including the YMCA, if it's in litigation. It was in multiple litigation, but the attorneys on the other side actually represented that YMCA in that case. So once we saw that, we went to the Ethics Commission and pulled his filings and realized that for the years in question, he was stating, I'm not on any board of directors. That process, therefore, brought in very difficult issues for the plaintiffs and, frankly, for me as counsel, because there's a criminal component to filing false ethics violations. So we were not going to, therefore, expose ourselves to the raising of these kinds of issues where there are criminal components to it, and saying,
but you did raise them, didn't you?
no, not in the notice.
I mean, here you can bring a motion to recuse and have a hearing on it. You can file a complaint with the Judicial Conduct Commission. You can file a complaint with the State Ethics Commission. There are lots of ways to proceed here.
Well, we did request in our motion that he recuse himself.
In your notice?
In our notice, yes, I'm sorry. We did request, if you look at the last page, we requested that he do so. But when there is an issue, and when I tell you, Your Honors, we spent hundreds of hours trying to figure out where there's an issue of a potential criminal violation, what is the responsibility in a motion session having nothing to do with the issue of the jury, but having everything to do with the judge, that we raise, you get off this case because there's a criminal violation and you're going to be reported. I'm not going to go that way. That's what our decision was. So it was we thought about it extensively so that we were not in the position where anyone could say we were trying to leverage this. We didn't even raise it in our original motion, our notice rather, all right? So with that, those are really troubling issues for us. And what we did was to check extensively. And there is no doubt, that no one is denying that he in fact was on the board of directors, that Johnson and Bornstein did represent them. There's no doubt about it.
What was the temporal relationship between the YMCA litigation and the litigation that you were involved in?
It was our case before Judge Murtaugh began in 2006. He was on the board of directors. He became a judge in the beginning of 2006, I believe. That case ended, I believe, about within a week of when we filed the case. All right, but also Judge Murtaugh was head of fundraising at the YMCA, and he was head of the executive committee. So the argument by my brothers is we didn't even know he was on that. Doesn't stand up, but the appearance of impropriety is unmistakable. So we simply said, look, here's the appearance. We're not making any accusations. Just allow us. Just recuse yourself, rescind your decisions, appoint a new judge. If one side or another doesn't like it, we'll be in the appeal process, and there it is. The answer is no, that's not going to happen. All right? Now, this is a building that is literally falling down, as determined by the jury and the Department of Public Safety. There are numerous decisions, including the Department of Public Safety's decision, 22 code violations, which was upheld by Judge Borenstein, because that was appealed. The contractor lost his license. The Board of Registration took away the licenses of one engineer and suspended the license of another. It goes on and on and on. We are in exigent circumstances
But
here.
this is I mean, we're not here about all of that. We're here about whether this is the proper venue to raise these questions when you have other routes that are standard and normal and are available to you.
Because the appeal issue is not the issue regarding Judge Murtaugh. The appeal issue is whether or not the jury found correctly and whether the decision should be overturned after a 30-day trial. So we have two separate issues. And I agree, we won, all right? We won the case. We're not here appealing the decision of Judge Murtaugh, per se, even though he's taken it away from us. We're saying just appoint someone who appears to be fair and reasonable and have no connection to the other side. I see my time is up, and if you have any other questions.
Thank you, Counsel.
Thank you.
Good afternoon. My name is Mark Johnson. On behalf of Johnson and Bornstein, I'm here representing Dante Malegny. A couple questions were asked of Attorney McLaughlin. One was, did the judge really refuse to enter judgment? You'll see that the judge indicated that once the breakdown of attorney fees was submitted under 93A, the judge indicated that he would be in a position to finalize judgment.
But I'm sorry, how can he finalize judgment if he allowed a motion for new trial?
He was finalizing the judgment, I believe, so that it could be appealed at that point, the decisions on the motion for a new trial.
He was prepared to allow.
Yep, under 93A.
93A.
Under 93A, that's correct. What he did was he...
Wait, I'm sorry. Was he saying, I will, under 54B, sever it and allow an appeal of my findings under 93A, or did he say, I will allow the motion for new trial, the allowance of that to be...
He allowed the motion for the new trial. As to 93A, he made specific findings ending after receiving the information from plaintiff's counsel, the court will be in a position to finalize its 93A decision and order.
Or 93A decision.
And
okay.
order.
Okay.
And that's on the appendix.
Okay, but I guess the question I have is, put aside the merits of this case. Let's assume there's a case in which all would agree the judge should have recused himself or herself. The judge does not, allows a motion for new trial. How do you get that to be heard by an appellate court, because the case is still going?
You can file a motion in the appeals court to hear the case. You can file a notice of appeal. What the plaintiffs have done in this case, and I'm not going to go over what the standard is for the review of the single justice's decision. I think it's pretty clear. I think the single justice was absolutely correct. Judge Murtaugh sent after the plaintiff filed their documents with Judge Murtaugh, a notice that he ought to remove himself. Judge Murtaugh sent out within a couple days a notice to all counsel saying that file it under 9A. If you believe I should recuse myself, the defendants have a right to be heard as well. The plaintiffs elected not to do that, but instead file a petition with this court. A number of the allegations that the plaintiff makes in their petition were also made in the initial filing with Judge Murtaugh. Quite frankly, the allegations the plaintiff makes in the various submittals to this court contradict themselves. There are allegations that the YMCA case that my office was involved in was pending in the same court as Judge Murtaugh. You could read some of the paperwork as indicating that it was pending in Middlesex County. Other parts, he says, it's Essex County. It was Land Court. It was over months before this case. I want to make it clear that my office has absolutely no relationship with Judge Murtaugh. There are over 33,000 people living in Andover. I live in Andover. It's a nice community. I couldn't tell you whether or not Judge Murtaugh lives in Andover. Judge Murtaugh may or may not be a member of the Andover Country Club. I am not. I never have been. If you knew my golf game, you'd understand why. Okay, the only country club in Andover I've ever been a member of, and I haven't been for a number of years, is actually a competitor of the Andover Country Club. I am very fortunate to represent the Andover Country Club. It's a family-owned country club. Judge Murtaugh is not an owner of the country club. I did make a donation to the Greater Lawrence YMCA. I'm proud of that donation. Maybe some people, I thought I'd be blasted for not contributing more, but I did contribute $100 to the Greater Lawrence YMCA. I don't know if it's affiliated with the Greater Boston. I understand it's not. We represented the Greater Boston YMCA in one matter. It was the validity of an easement that was brought in land court, and we were successful in finding that the easement did exist.
When did the YMCA litigation end with respect to the pendency of this case?
A number of months before.
Before this case was even filed?
Before this case was even filed. We have submitted. I mean, part of the problem is that the plaintiff seems to believe that if you say inappropriate relationship a number of times, eventually it's going to be true. The problem is the facts don't bear it out. The YMCA case was decided on September 8th, 2006 by Judge Lombardi in the land court. That's when the decision came out. This case was filed a number of months later. I had absolutely no contact with Judge Murtaugh, didn't know he was on the board of directors of the Greater Boston YMCA. Okay. The bottom line is you can claim an inappropriate relationship, but at some point you have to do more than claim an inappropriate relationship. I find it very interesting that in the reply brief filed by the plaintiff, page 4, they say, the issue in this case is not whether or not the conduct underlying petitioner's claim of the appearance of impropriety is true, but whether or not the conduct supports the petitioner's claim. I don't know what that means. I mean, I read that and it's telling me the issue is not whether or not the conduct underlying petitioner's claim of appearance of impropriety is true. Well, that is the issue. Okay, you can't make these allegations without a factual basis for it and then use that as a reason to have a judge recuse himself because there was a decision you disagreed with.
Mr. Johnson, your time is up.
Thank you.
Thank you.
Good afternoon. Christopher Mafucci for the respondents. I'll get right to the point. The petitioner's petition is filled with accusations and maligning a trial court judge without any evidence supporting those accusations. In fact, I went through and tallied at least 30 representations maligning the judge for his actions in the trial court by plaintiffs without citations to any record evidence. A couple of times there were citations to the notice of violations, their own pleadings, but no record evidence supporting these claims. Now, it's true that the judge is on the board of directors for the Greater Boston YMCA, but as counsel had stated, he is not the head of fundraising. That is a new allegation that has appeared today. That would be a violation of the ethics of judicial conduct. But that allegation just popped up during argument today. If you go and look at the record, there is absolutely no evidence to support that claim. Their brief is filled with those types of accusations. It also states that today, counsel stated that the judge is the director of finance. There's no evidence to support that, although in their brief, they cite to their own earlier brief in which they say perhaps he's the director of finance. They make accusations in their briefs and today without any evidence to support. And the court should strike and dismiss the accusations against the judge because there's no basis for those charges. Judges do not live in bubbles, okay? The fact that the judge is a member of the YMCA, the board of directors, is not an issue. It doesn't mean anything to this case. As stated from my counsel here, that the land court case that was the big issue in petitioner's brief was just resolved before the judge took the bench, and also it was on the land court and not before the Superior Court. What's also admitted from petitioner's brief, besides evidence of the judge's wrongdoing, is the fact that the alleged bias against his clients and in favor of Mr. Johnson's clients, is the fact that the record shows that there were numerous motions decided against Mr. Malegny, who's represented by Mr. Johnson, including a finding of 93A liability against Mr. Malegny. So to say that this impropriety, appearance of impropriety, is also based on, also backed up by substantive bias, there's just no evidence to support that in their briefs. And it's also interesting, or also worth noting, that the judge's post-trial decision, which is the real reason why we're here, the disgruntled litigant with a decision of the trial court judge in the post-trial phase, the judge ruled in his first post-trial decision that the plaintiff's verdict could not stand because there was no evidence to support the finding by the jury. The judge wrote in his decision that the reason why the verdict could not stand is because plaintiff's experts did not testify as to damages, the cost of repair damages for the defective house that plaintiffs have complained about. And without that, there was insufficient evidence to support the jury verdict. And there was no evidence provided by expert testimony to support a diminution in value, another form of damages that plaintiffs could have proved. Why didn't plaintiffs put on this evidence? We don't know. Only the plaintiffs know that. But they had ample opportunity during the trial. In fact, there were numerous sidebars and argument outside of the purview of the jury in which the issue of evidence, the lack of evidence, came up during the case, during the trial, and plaintiffs chose to stay their course and not put on that evidence, even though the trial judge had warned them that there was going to be a problem. And sure enough, it happened. Okay? The jury got it wrong because they got a standard damage instruction. They sent questions back to the judge during the deliberations. Can we order the property returned in exchange for a full refund to by the builders? The judge said, you got to go with damages only. The jury came back and refunded the full purchase price. The judge said that couldn't stand because there was no evidence to support it. It's the proper decision. There's no evidence of bias. And I see that my time is up. Thank you.
Thank you, counsel. Thank you.